Picture this. You get a text in the middle of the day. They're turning them against you. Your heart drops. You start replaying every missed call and every awkward handoff. Suddenly, everything looks like proof. You're not alone in that panic. Welcome to Danny's Den. Today we're diving into what that phrase really means in the courtroom, what actually matters, and what you can do right now to protect your child and your traditions. Let's chat. Okay, quick reality check. What people call parental alienation at the kitchen table is often not the same thing a judge sees in court. Look, judges look for patterns, intentional, sustained efforts to undermine a child's relationship with the other parent, not a single bad visit or a kid bouncing toward the parent who did bedtime that week. So how do courts tell the difference? They ask questions like, is contact being blocked? Are there coached phrases? Is there a repeated interference with exchanges? A single angry text? Not usually enough. A campaign of denigration, missed visits, and blocked calls? That's a different story. Here are behaviors that really concern courts. Repeated obstruction of visitation, blocking phone calls, coaching kids to repeat negative statements, or fabricating allegations. Those are serious. And here are the things that often get overblown: venting to friends, private frustration, or a child's normal resistance after a major change. Important, but not always proof of intent. Don't rush to the judge with feelings and slogans. Build specifics, dates, messages, missed exchanges, witnesses. That's the kind of evidence courts understand. Start with a simple, court-friendly documentation habit. Save time-stamped texts and emails. Screenshot voicemails. Keep a short, dated log of missed pickups or blocked calls. Just the facts, one line per entry. Example of a helpful log entry. Oct 5, 3:12 p.m. Missed pickup. Child returned to my house 30 minutes late. Witnessed I neighbor. Short, specific, verifiable. You might think, but what if they delete things? Here's exactly what to do. Take screenshots immediately. Email them to yourself so the timestamp shows, and back them up to the cloud. If a message disappears, the screenshot and email chain can still prove it existed. Keep originals when possible. Move heated topics off text and into archives. Say something neutral like, for scheduling, please use email or our family calendar so we both have a record. Short, child-focused, and unemotional. If a confrontation happens in front of the child, remove them politely and de-escalate. Later, write down what happened and who saw it. And if you fear for physical safety, contact local authorities or an advocate. Safety first. Courts do use experts sometimes. Therapists, evaluators. But an expert's report is only as strong as the collateral evidence, consistent records, testimony from neutral parties, and observable patterns. And be realistic about likely outcomes. Judges prefer stability. Initial remedies are often therapy, parenting classes, or supervised exchanges, not immediate custody swaps, unless the evidence is clear and serious. Now, a practical parenting piece. Traditions matter. Small rituals anchor kids when everything else is chaotic. If Eagle Sundays or Yankees nights matter in your family, keep them predictable. Make game day logistics simple. A shared calendar with times, a labeled game day bag that travels with your child, and a short positive ritual that stays child-centered, not a scorecard for who wins the weekend. Music is a low-conflict anchor. Pick one song that means safety. Call it the game day mix or comfort mix. Share it with your child and keep it accessible. If access ever gets messy, the playlist exists outside the fight. Short scripts that work. Instead of accusing, try, I want the kid to feel safe with both of us. Let's keep things positive around them. Or, I'm stepping away to cool down. Let's handle scheduling by email. Calm, child-focused, and it builds a record. One caution. Don't manufacture evidence or manipulate interactions to prove the other parent wrong. Courts see gamesmanship. Stay honest, document real behavior, and try mediation or therapy before escalating. Before we close, 3 simple actions you can take today. Start a dated log and preserve electronic communications. Move scheduling to written channels. And protect at least one child-focused routine, a game day ritual or calming playlist, and keep it consistent. Remember, not every hard situation equals parental alienation, but intentional interference is serious and needs evidence. If you're unsure whether what you're seeing crosses the line, consult a local family law attorney or a licensed child therapist who understands custody dynamics. For a small, immediate reset, pick that one safety song and make it part of your routine. Play it before school, at pickup, or on game day. That simple cue can be steadier than anything we argue about. Thanks for spending these minutes with me. If this episode helped, subscribe to Danny's Den for weekly law, love, parenting, and sports guidance you can actually use. If you need case-specific legal help, visit my website contact page to book a consultation. Let's chat. Thanks for listening to Danny's Den. Take care, protect your kids' routines, and keep those playlists ready.